Navigating the aftermath of a relationship breakdown can be challenging, and we recognize that it can be difficult to talk to your ex-partner about sensitive topics, such as child arrangements or the division of finances. That's why, at WSP Solicitors, we're introducing a more amicable and cost-effective approach to separation. Welcome to our step-by-step guide to family mediation, a less complicated path towards resolution. MIAM, or Mediation Information and Assessment Meeting. You will individually meet with your mediator, either face-to-face or online. At the MIAM, the mediator will gather information and find out what is important to you and what you want to achieve. The mediator will also ensure that mediation is appropriate for you both. Next, you both will need to provide financial disclosure. Both parties, with the support of the mediator, will disclose to the other their financial information and provide supporting documents like payslips and bank statements. This disclosure ensures fairness and openness and is crucial for the agreement to be legally binding. The mediator will help you to reach an agreement over the financial disclosure. The mediator will also help you identify any missing information. Once agreement on the final disclosure has been reached, your mediator will provide you with a summary of the agreed financial information. Many people involved in mediation often find at this stage it's helpful to obtain some initial legal advice, or you may need the help of an expert, such as an accountant or pension expert, prior to discussing proposals. Your mediator can signpost you in the right direction. This helps ensure that any proposal is reasonable and will be capable of being approved by the court. Now that you have an understanding of each other's financial information and have perhaps taken some expert advice, you will be in a position to start discussing solutions and considering proposals that best meet your needs and those of your family. Typically, you will need to consider factors like income needs, housing needs, childcare, pensions sharing, debt and liabilities, the contents of the house, etc. You both need to work together with your mediator to arrive at an agreement that is fair, reasonable, and works for you and your family. When an agreement has been reached, your mediator ensures the agreement is affordable and practical. Your mediator will ensure you have considered your needs, how you'll afford to live now and in the future. This helps the court see you've considered each other's needs. Making the agreement legally binding. On completion of the mediation process, your mediator will draft a financial statement and a memorandum of understanding, setting out what has been discussed, agreed, and the reasoning behind the agreement. You can then take these documents to a solicitor, who will use them to draft a financial consent order, which can be filed at court. Once the court has approved the order, the agreement will be binding. Remember, mediation is a voluntary process, so you both need to be willing to work together. If you can successfully work together, it will allow you to reach an agreement that best meets your family's needs. Mediation will be quicker and more cost-efficient than proceeding to court. If you want to work together, the best time to start mediation is as soon as you have decided to separate or divorce. If mediation sounds like it could be the way forward for you, then please contact WSP Solicitors to speak with one of our mediation experts today. With WSP Solicitors, it's life less complicated.